This podcast may contain disturbing content for some listeners. It's intended for mature audiences. Listener discretion is advised. This is True Crime XS.
Do we want to talk about that on this episode or no?
I figured we could do it with the Girl Scouts, but whatever you want to do is fine.
Yeah, that's what I was thinking too. I was reading today about I think I commented to you how much blood is left by killers at crime scenes when it's a shooting.
Yeah, I can only imagine he was scratched or something. I don't know. Like, shooting is very impersonal. You don't have to be close to someone, right?
Yeah, so this is an arrest in Virginia that I saw today. I get down these really long rabbit holes, and I'll just read some news to kind of get out of it for a minute. And so this was actually May 27th. They announced this out of Virginia. It's a double homicide of two Pennsylvania women, which apparently took place over 10 years ago. It was Beatrice Daniels and Christine McWhorter. They'd been killed in Pennsylvania in 2009, but a Newport newsman was arrested on those charges. He was taken into custody. A guy named Morrico Johnson. He's 47 years old. He's accused of fatally shooting Christine and Beatrice 13 years ago in Mount Union, which is about 130 miles east of Pittsburgh. The way that they put this together was with Parabon, which is based out of Virginia. The state police in Pennsylvania got involved, and they used genetic genealogy to go on to public genetic databases like 23andMe, and they crafted family trees, which is something you've described over the years. But the way they did it in this case is what I was really talking about. The blood sample used to tie Mordico Johnson to the crime scene was collected after state police had found them dead. They had gunshot wounds to the head on January 3rd, 2009, but droplets of blood were found throughout the apartment, on the staircase, and on the doors. But a DNA analysis found that the blood didn't belong to either woman. It was an unidentified man. So in the course of this investigation, they find out that these are very clean people. They would never have left like these spots that they found around. So in 2016, police turned this unidentified DNA sample over to Parabon, and they developed a portrait of the potential killer using what we know as DNA phenotyping. The analysis indicated that the blood belonged to an African-American man with green to hazel eyes, brown to black hair, and a light to medium complexion. So they run the sample through another round of testing in 2018, and they use genetic genealogy, and they get a hit where Johnson's name appears. The DNA report ends up from Parabon. It ends up offering a lead, and it indicated that Johnson could be the source of the blood at the crime scene. So investigators then have to go and get a DNA sample from Johnson. So they interview him in 2019, and he told police at the time that he had been dating McWhorter's best friend. So Johnson had traveled to Mount Union, but he told them he had never been to her apartment. So he agreed to a DNA swab during this interview, and his sample was a match for the blood left behind. And there were other circumstances that end up lining it up, because I know you don't like to just have a DNA sample when you're looking at the thing. You like to know more that it.
There's always that chance that, it could be he just was visiting and had a nosebleed, but it sounds like they kind of penned it down to where that wouldn't have been the case.
Yeah, the weekend that they were killed, apparently Johnson had plans to visit Mount Union, but they got canceled at the last minute. He had found out that his girlfriend at the time was seeing another man, and he had been working for the New York Department of Corrections, but though they found a time card and a request for time off from work from January the 2nd, where he had said he would be back to work January the 3rd. And for some reason, all of this stuff added up to it likely being, him. And I think it's a one-off murder. It's probably the only one that he committed. I do not actually know why he committed the murder. But whatever it was,
His girlfriend was their roommate or best friend. What?
it doesn't specify, because the girlfriend that he had from the time is listed in the interviews from police. So it basically it says they interviewed more people. They interviewed Johnson's half brother and his girlfriend from the time. The brother told police, this is an interview in 2020, that Mordecai knows firearms and that he had spent time as an armed security guard. And he added that their late father owned the type of gun used in the killings, and his belongings were passed down to Johnson in 1998. So essentially, he had a reason to own the murder weapon sort of off the books, because it would have just been like a inheritance type situation. And it says Johnson's then girlfriend said she had plans to visit Mount Union the weekend McWhorter and Daniels were killed, but they were canceled at the last minute because she opted to spend time with another man.
So he thought she was going to be there. That's what happened.
So he killed two people that had nothing to do with what was going on. That's wild.
I think he was after his girlfriend who was with somebody else, and she wasn't there, and so he, I don't know how it went down, but however it went down, he didn't feel like he could leave them alive. So
he went.
It was rage. I mean, it was over love, and it was rage.
That is crazy pants. So that's
yeah, that's crazy.
That's true crime news for this week. It came up in my news feed. I've been down several other rabbit holes, and that one came about. We have been working this different idea of trying to help someone out in Dallas. I'm pretty sure that's going to be the episode right before this. When I looked at, it might be the episode after, though. Depends on how I put this together. When I look at cases down south, and you know this, I get like a little crazy on the relationship of racism to the courts over the years, and like it has all sorts of weird effects at different times, and like sometimes it makes me crazy one way or the other trying to figure out what happened to somebody. But I'd say, like, of those cases that I spend the most time on, it's usually the ones that are like death penalty cases.
Sure.
I have a soft spot for anybody who ends up on death row, and there's like even a remote possibility that they shouldn't be there. But I don't like to get super controversial about capital cases, but I would say that my feelings, I've been pretty ambivalent on my feelings about capital cases. And one of the things I think that stands out is how we treat people who are intellectually challenged. Have you ever looked at a case and gone, I don't know if that guy could have done this or not, but like, why are they stopping it, or why are they like going ahead with it?
I feel like, we've looked at tons of those cases. Yeah. I've actually asked you, like, did they do an IQ check on them?
on this defendant, yeah.
On different people, sure. I mean, it's always in the back of my. That's one of the things I would have to tick off. Competency.
Yeah, I got so my rabbit hole that I went down. This is not like the main case. This is sort of like what led me here. Was I found this Atkins versus Virginia case. Looks like it's sort of the holding case currently for how we treat executions of people with intellectual disabilities. And the holding was essentially 6-3 that executing people with intellectual disabilities violates the Eighth Amendment's ban on cruel and unusual punishments, but it allows states to define who has an intellectual disability. And at the time that Atkins was decided by the Supreme Court, which would have been 2002, 18 of the 38 death penalty states exempted intellectually disabled offenders from the death penalty. And there are some subsequent developments related to that case that we'll cover. But I did want to talk about Atkins versus Virginia and sort of how this went down. It's like pretty difficult to get a case in front of the Supreme Court in general. I found a writ of certiorari to the Supreme Court of Virginia related to this case that sort of outlines what these guys did. In this particular case, it's pretty run-of-the-mill crime. It's from August 16th, 1996, the crime itself. Around midnight, a guy named Daryl Renard Atkins and a gentleman named William Jones, who was armed with a semi-automatic handgun, they abducted a man named Eric Nesbitt, and they robbed him of the money he had on him, and they drove him to an automated teller machine in his pickup truck. And cameras recorded them forcing the withdrawal of additional cash. Then they took him to an isolated location, and they shot him 8 times, and they killed him. There's a trial. They're caught. There's a trial. And both William Jones, and Daryl Atkins testify in the guilt phase of Atkins' trial. So each of them confirm most of the details in the other's account of the incident, but there's an exception. So the exception that is talked about in what they call the writ of certiorari here, it's an important exception. They each stated that the other had actually shot and killed Nesbitt. So they agree that they abducted this guy, they took his money, they took him and got more money from an ATM in his truck, and then they took him to an isolated location and they shot him 8 times. And at the end of it, Eric Nesbitt was dead. They agree on that. Jones's testimony, which appears to be more coherent and is therefore considered more credible than Daryl Atkins, he is obviously the one the jury believes. And it's sufficient to not only establish Atkins' guilt, but at the penalty phase of the trial, the state introduces different victim impact evidence, and they proved 2 aggravating circumstances. Aggravating circumstances are circumstances that weigh towards the offense being worthy of a heavier punishment. Whereas if there were mitigating factors, it would mean that the court or jury or whoever could potentially weigh them in favor of a lighter sentence. Instead, these 2 aggravating circumstances lean towards a heavier sentence. Specifically, the 2 that they found here were future dangerousness and vileness of the offense. To prove future dangerousness, the prosecution relied on being able to show that Daryl Atkins had prior felony convictions, and they also allowed the testimony of 4 victims of earlier robberies and assaults. So what they did there is they bring in people and they say, this is what he does to his victims, where he pistol whips them, or he ties them up, or he shoots them, or whatever it is that the defendant is accused of doing. During the penalty phase, it's where the state is allowed to give the jury and the judge evidence of he will do this again and it will be bad. That's future dangerousness. Would you agree?
Yes.
So the second aggravating factor, vileness of the offense, means that the offense offends the conscience. In this instance, the prosecution relied upon the trial record, and basically they used pictures of the deceased body and the autopsy report to prove that this was a particularly heinous way for someone to die. The defense only relied on one witness during this, and it was a forensic psychologist named Dr. Evan Nelson, who had evaluated Atkins before the trial, and he concluded that Atkins was mildly mentally retarded. That is a quote from the court papers. His conclusion was based on interviews with people who knew Atkins, a review of school and court records, and the administration of a standard intelligence test, which indicated that Atkins had a full-scale intelligence quotient, or IQ, of around 59. Depending on where you live in the U.S., the bottom side of the IQ scores tends to be around 70. So a 59 is pretty low. The jury sentenced Atkins to death, but the Virginia Supreme Court ordered a second sentencing hearing because the trial court had used what they considered to be a misleading verdict form. So during the resentencing, the state and the defense are allowed to present their cases again for how sentencing should go. And again, Dr. Nelson testified, but now the state is allowed to present an expert rebuttal witness who, his name is Dr. Stanton Samenow, and he expresses the opinion that Atkins was not, quote, mentally retarded, but rather was of average intelligence at least, and that's all quoted, of average intelligence at least, and that he was diagnosable as having an antisocial personality disorder. So the jury again sentenced Daryl Atkins to death for the murder of Eric Nesbitt. The Supreme Court of Virginia affirmed the imposition of the death penalty because when you're in a death penalty case, one of the instant things that happens is you're pretty much automatically eligible for appeals. And these appeals are basically to make sure that we're not missing anything in terms of actual innocence or procedural error before we put someone to death. Some of these appeals get to be a little bit rote, or like they're just being done sort of to follow a procedure. But so Atkins' attorneys, and when you read these different documents related to stuff like this, it'll say Atkins did not argue, but really they're saying that no one argued. The attorneys or representatives related to this case did not argue before the Virginia Supreme Court that his sentence was disproportionate to penalties imposed for similar crimes in Virginia. But they did contend that he was mentally retarded and thus could not be sentenced to death. So the state court, the majority rejects the contention, and they indicated that at the Virginia Supreme Court level, the court was not willing to commute Atkins' sentence of death to life imprisonment merely because of his IQ score. There was some dissent there and some agreement there. The dissent, meaning some of the people who disagreed, they said that Dr. Samenow's opinion should be rejected and that Atkins they were rejecting the idea that Atkins possessed average intelligence, and they specifically rejected it as incredulous as a matter of law. And they concluded that the imposition of the sentence of death upon a criminal defendant who has the mental age of a child between the ages of 9 and 12 would be excessive. So this court becomes involved, the Supreme Court becomes involved, and basically they rule that it's wrong and a violation of the U.S. Constitution's 8th Amendment to execute people who may not fully understand, because of an intellectual incapability or disability, the gravity of the crime that they have committed. Would you say that's a fair way to state all of that?
Yes.
The way that this ends up going for Daryl Atkins, so he goes back and forth over the years, and a jury in July 2005 gets the case again in Virginia. They actually decide that Atkins was intelligent enough to be executed on the basis that he had constant contact with his lawyers and that he had intellectual stimulation, and they believe that his IQ was raised above 70 by his contact with his lawyers. And they decided that he was competent to be put to death under Virginia law. And the prosecution had argued that his poor school performance was caused by his use of alcohol and drugs, and that his lower scores and earlier IQ tests were tainted by the substance abuse. So his execution date was later set for December 2nd, 2005, after this is heard in 2002. January of 2008, there was a circuit court judge named Princess Smiley who was revisiting the matter of whether Atkins was mentally disabled. And they had received some allegations of prosecutorial misconduct. Those allegations, if true, would have authorized a new trial for Atkins. So Princess Smiley held a hearing and determined that the prosecutorial misconduct had occurred. And at this juncture, Smiley was faced with the decision of vacating Atkins' conviction and ordering a new trial. But instead, Princess determined the evidence was overwhelming that Atkins had participated in what Smiley considered to be a felony murder, and they commuted Atkins' sentence to life in prison. This goes back and forth where the prosecution says this is wrong, and they claim that Princess Smiley has exceeded their judicial authority. But on June 4th, 2009, the Virginia Supreme Court, in a 5-2 decision that was authored by Chief Justice Leroy Hassel Sr., they ruled that neither mandamus nor a prohibition was available to overturn the court's decision to commute the sentence. Basically, they're saying it might be wrong, but we don't have a way to tell a judge they can't do that. There's a pretty lengthy dissent in here that you can read on talking about the majority's reasoning, and that they believed they should be critical and sort of lambast Princess Smiley publicly for having dared to commute this sentence. But the idea was Princess Smiley was trying to be what's called judicially efficient. He believed that a new trial would result in Atkins, who has already admitted in his own testimony when he testified in various stages of his court proceedings that he was a participant, was probably not the brightest bulb for that reason alone, that he basically could not argue his innocence at this point. So there was no reason to have a new trial when it did appear that he had committed a felony murder, which is a felony murder is essentially if you're committing any felony and someone dies in the process, no matter how they die, you're responsible for what in many places can be punished as first-degree murder. All right, now my rant's over. This is how we get to like the case I was going to sort of take a look at today. But the holding right now in 2002, it is technically Atkins versus Virginia. We cannot execute people with intellectual disabilities because it's a violation of the Eighth Amendment's ban on cruel and unusual punishment. Therefore, it is cruel and unusual to execute people who, for whatever reason, don't have the capacity to truly understand the crimes they've committed. What do you think about executing intellectually disabled people?
Well, it's interesting because I actually I live in denial of any political opinion of like the death penalty. Like I don't want to say I just don't care, but like it's something that happens, right?
Yeah.
And I don't want to come off like, pro or against it because it's so far out of my reality that it doesn't matter to me as much. But I will say this. I feel like people with intellectual challenges should not be executed. I also feel like if the initial death sentence in this case had been commuted to life in prison, it would have saved a whole lot of people a whole lot of trouble.
Yeah.
And I don't necessarily, so what I'm saying there is like, I guess when it comes to whether somebody's going to stay in prison for the rest of their lives or we're going to kill them, I'm kind of I would, if they challenge it, I would just as easily let them stay in prison the rest of their life. I mean, it's not like people are able to break out of jail at this point, right? I mean, it happens occasionally, but for the most part, it's a punishment that's going to stick, right?
I would say life in prison is probably at this stage of the game a a worse punishment than the death penalty in
Well,
some ways.
sure, and of course, but I guess my point just would be that you hear a lot about how, like, our system's broken, and there's all this clog in the, the sort of process that everybody goes through, and a lot of this stuff. I mean, here you've got this case that it goes to the Supreme Court, who there's a syllabus, an opinion, a dissent, and another dissent. So alone, you've got three different points of view here coming from the United States Supreme Court. And there was a lot of stuff happening, which is why the court heard it to begin with. And then at the end of that, it is reversed and remanded back. And they go through everything and they reach the same conclusion again, right?
Yeah.
Okay, that is unnecessary. Things like this are why, the system's broken and everything's clogged up. Because, you've got the state and the defense attorneys having to argue this out over a really long period of time, right? Like 10 years. And when you've got the highest court saying, like, you can't put this guy who has this factual information that was entered into evidence at the time of the trial, that he had intellectual challenges. You've made this establishment, like, they didn't go through the trial and then decide it, right? Like, it was part of it all along. And so, that goes against Eighth Amendment, and, it's cruel and unusual. And I do agree with that. Just like I would say, like, you can't put a child to death, right?
Yeah.
It is the same sort of thing. Now, it is completely ridiculous when you've got the Supreme Court hearing this, giving the remand, the reversal and the remand, then it going through a whole new set of litigation, and then what you were saying at the end with Princess Smiley commuting the sentence, and there's still being backlash, right? And part of our system is that things don't get re-litigated repeatedly.
That's the idea, yeah.
Well, and to me, it sounds like there were a lot of holes here, and a lot of, they didn't want him put to death. And I would say that was worth fighting for, certainly. But my perspective on it comes from more of, like, at the very beginning, when the punishment's being given, the aggravating factors led to them sentencing him to death. And from a judicial point of view, I would say if there's questions that are legitimate, like in this case, there were legitimate questions as to his intellectual capabilities, right? And they weren't something that was just brought up, like, after the fact as kind of a Hail Mary to try and get him not put to death, right? It was a legitimate point that had been made. I feel like anytime there's sort of questions about that kind of thing, I feel like to be judicially efficient would be to commute the sentence.
Yeah, I think that's the smartest move. And one of the other things that you have to consider is, and I don't want to go too deep into this because there's something I want to talk about true crime related, but when the Supreme Court gets a case, first of all, having personally tried to do that, I can tell you that getting a case to the Supreme Court is not a small feat just to get it petitioned and heard. It's a huge, huge mountain that you have to climb, legally speaking. Would you agree with that statement?
Yes, and it's also not the finality of what you would expect. In this case, demonstrates that, because even amongst the justices, you've got different opinions, and it's basically majority rules, right? And
Right.
you have to kind of keep that in mind. All legal decisions from, the Supreme Court, they're appointed by the justices are appointed by the president, right? And the president is the executive branch. The justices are the judicial branch, and the things that are being interpreted by the justices of the judicial branch are made by legislators in the legislative branch. And so that it's part of our checks and balances system, right? But when they're giving their opinions, they don't always agree. And to me, it's always been really confusing when you've got the law of the land, which would be the Supreme Court's ruling, and you've got dissenters, and you've got reasonings why the majority ruling doesn't make sense. And every single judge, to some extent, they can insert their interpretation of the law, and it's just a level by level, appeals process.
It's so hard, though, because I think there's a lot of ramifications to a Supreme Court ruling.
Right, but it can be ignored.
It can be ignored to some degree, and it can cause further litigation to other degrees that don't necessarily agree with the original rulings.
Well, it sounded to me like Atkins basically, they just decided that the initial, what was put forth initially, that he did have some intellectual challenges, was just, they just didn't think it was important or relevant, right? And so they ended up sentencing him to death again, right?
Right.
Okay. And so you can't just take that out of the equation. And so what ultimately ends up happening here is the sentence gets commuted, which is what should have happened initially without that extra litigation that occurred.
Yes.
So, while it can be ignored a little bit, I guess eventually it has to come back into balance. And that's what happened here. It just took 10 more years or whatever.
Yeah. So I have a case that's related to what we're talking about, believe it or not. And the case that I'm looking at it's down in Dallas, and it takes place in the mid 80s. From a glance, it is I guess I could say it's a serial case, at least according to what I read in terms of the newspaper articles from the time. This case involves the death of three different women, but it looks like there's only one that's actually a conviction, tried and a conviction. So supposedly, a gentleman there named Charles Anthony Boyd, who is later nicknamed the Bathroom Slayer, committed 3 rapes and murders in North Dallas. So the first one on the list here is July 22nd, 1986. It's a 37-year-old woman from Thailand named Chapawa Nakusan. She lived in an apartment just upstairs from Charles and his brother, and she worked as a waitress. And she was found stabbed and suffocated to death in her bathtub. On September 15th of 1986, an apartment cleaning lady came upon a woman, 22-year-old LaShawn Thomas. She was dead in her apartment bathroom, and she had been fatally stabbed. And then on April 13th, 1987, there's a 20-year-old woman named Linda Williams who returned home to her apartment from work and found her roommate, 21-year-old Mary Milligan, stuffed in a bathtub, having been raped, strangled, and drowned. So while investigating this, police began to assume that her killer was the same one who had killed Naxawan and Thomas. So that's July 22nd victim and the September 15th victim. And by that time, locals in the media began to apply a pseudonym of the Bathroom Slayings to these murders. While observing the scene of Milligan's murder, it was found that some items had been stolen from her apartment, and her car, which was a 1982 Cadillac, was also reported to have been stolen from the apartment complex's parking lot. It was later found abandoned. On April the 14th, 1987, Charles Anthony Boyd was arrested after being found in possession of Mary Milligan's personal items, which he was trying to sell. He was basically trying to pawn items that had been at the crime scene. Subsequently to this arrest, a blood and hair test of items left at the scene exposed that Boyd was probably involved in the crime or had at least been to the scene at Mary Milligan's murder. After his arrest, he confesses to all three killings. In late April of 1987, Boyd is charged with all three murders. And despite this, despite the fact that he's charged with all of these murders and he has apparently confessed, prosecutors opened the trial in early October of the same year, with him only being faced with the charge of killing Mary Milligan, primarily because there was forensic evidence in that case that was not available in the other cases. So Charles Boyd gets indicted on a capital murder charge for killing her. And because he admitted to the killing, his defense decided to go with the claim that he was, quote, mentally retarded, or what we were describing as intellectually disabled. Their argument at this time in the 80s, specifically 1987, was that he could not be given a death sentence. The lawyers raised Charles Boyd's IQ was 67. However, one of his prison files estimated that his IQ was probably more like 80. This jury trial takes place over what appears to be 3 days. The jury deliberates for 10 minutes, and ultimately they reach a guilty verdict in November of 1987. And a month later, in December of 1987, they sentence him to death. In terms of like all things that you'll ever hear, this guy was a good suspect. He had been accused previously of having been, I said accused, but I think the word I'm looking for is convicted. He had previously been convicted of a sexual assault and a robbery. And his appeals process is pretty lengthy, although I will say for a death penalty case and for it being Texas, it's relatively short. The reason this case caught my attention is that on August 5th, 1999, Charles Anthony Boyd was executed by lethal injection in the execution chamber at the Huntsville unit in Huntsville, Texas. Prior to his execution, he was asked if he would like to make a final statement, and he declined. But as the drugs took effect, the lethal injection took effect, out of the blue, he made a proclamation that he was innocent. And he said, "I want you all to know I did not do this crime. I wanted to wait for a 30-day stay for a DNA test so that you know who did the crime." Not long after, Boyd let out a gasp, and then he went silent. And at 39 years old, he was pronounced dead at 6:16 p.m. on August 5th, 1999. What bothers me about that is I don't think people so how much do you know about lethal injection, Meg?
I know that you're given something to relax your body, and then you're given something to stop your breathing.
Yeah. Typically, what you end up with in the United States is it's a cocktail of three. I would have to check the time for Texas to make sure that that is an accurate statement. But the gist of it is you get a barbiturate, like a short action barbiturate. In a high dose, it's essentially an anesthetic agent that will knock a person out in under a minute. And typically that's either pentobarbital or sodium thiopental. So the reduction of respiratory activity, what's known as a depression of breathing, is one of the characteristic actions of the drug. Consequently, the lethal injection doses, they're pretty high. And when you get this barbiturate, even in the absence of the other two drugs that they put with this, a lot of times death would be caused due to lack of breathing. It slows your breathing rate that much that basically you just stop. But then additionally, there's a substance named pancuronium bromide. And now it's a muscle relaxer, and it basically causes almost instantaneous paralysis, which paralysis in this case would be all of your skeletal muscles, which includes the diaphragm. And so on top of the barbiturate, you would also stop breathing because a high dose of this drug would eventually cause death by asphyxiation or lack of breathing. And they use potassium chloride in this mix. Potassium chloride is interesting, but what it does is it causes an abnormal heartbeat and essentially stops the heart from beating. That is how you are supposed to be put to death by lethal injection. What's interesting is the first drug in this case being sodium thiopental, even pentobarbital would be the same. People on that drug don't tend to shout lies. In fact, the way that this drug works, it's just a relaxing barbiturate where different types of anesthetic uses come about because it essentially allows a person to be weakened to the point that they don't have like the biological mechanisms that you would find. In fact, there is a version of these two drugs that is known as a truth serum. The idea is that it weakens the resolve of the subject to defend themselves, and it weakens our natural defense mechanisms. But it also decreases higher cortical brain function and our inhibitions. So our instincts to lie to protect ourselves go away pretty quickly. So to shout out those words caught my attention. And that is specifically why we're talking about this case today, and why we're talking about it in conjunction with intelligence quotient levels. So with the case of Charles Anthony Boyd, did you read over like kind of the long form links that I sent you about his case?
Yes.
In general, like his case really becomes about his school records. I mean, and like his IQ tests.
Before we start that, let me ask you something. So this is the quote, and it is a quote. I want you all to know I did not do this crime. I asked for a 30-day stay for a DNA test so you know who did the crime. End quote. Right?
Yeah.
Is that accurate?
That's what it says.
Okay, and so how would a DNA test from him show them who did the crime? Keeping in mind that this is 1999.
I don't, are you baiting me? Because I have a theory, but I don't.
I'm not baiting you. I'm legitimately, because to me, you said that like having been given this initial dose of what could, pass for like some sort of truth serum before the lethal part of the lethal injection is happening, right? He expresses, he says, quote, I want you all to know I did not do this crime. I asked for a 30-day stay for a DNA test so you know who did the crime, end quote. Okay.
Yeah.
That seems very wordy to me.
I agree with you, by the way. I have questions about if that's accurate.
Okay, and so to me, something like, I want you all to know I did not do this crime, and the reason I wanted a DNA test was so you would know I did not do this crime.
Right.
Something like that. And so I know it's like playing with semantics there, but like how would his DNA test show them who did the crime? What's that thinking there? I mean, because to me, it could show them that he didn't do the crime, but it wouldn't show them who did do the crime.
It could.
If it was his brother.
Yeah. This guy's like, I don't know, like how much we're like, I don't know how much we're allowed to like get into that territory where we just accuse somebody outright. I will just say this about him.
I wasn't accusing anybody. I'm just analyzing his final statement. That's it.
So if this guy's mental capacity was even 80, and like if you read through the court documents, they are pretty complex, but essentially what the United States Courts of Appeals and the Fifth Circuit had it. What they found in 1999 was, yeah, this guy probably is intellectually disabled, but it doesn't violate Texas standards. And like he could even be average, and we would have to choose. We would be conflicted trying to choose in this evidence. And the trial court ruled this way, and we have no basis to overturn what the trial court ruled. All of that having been said, this guy works as a janitor. And somehow his IQ is being split between, is it 60 or is it 80?
I think it was 69 and 80.
That's probably right. Like I see references.
So that would 1 point off. Like the standard for an intellectual challenge is 70, so he would be 1 point below it.
Yeah, so they took some averages here, and like if you look at it, he has a test where he scores as low as 64. One of his prison packets indicates that he had a 67. He's tested at a 69, but there's an earlier prison packet in his life prior to him being 27. He's 39 when this argument's being made, where it was indicated that his IQ was probably like 80. I'm going to go with, if you have a 62, a 67, and a 69, and then an 80, the 80 is probably the anomaly. Personally, don't you think?
Yeah, that would be true. I just haven't seen all those numbers.
It's in the Court of Appeals Fifth Circuit decision in there. And right in the middle of it, it says that according to Boyd, his trial counsel performed efficiently in failing to discover mitigating evidence of his mental retardation. At trial, his attorneys introduced 2 prison packets that were created during Boyd's prior incarcerations. One prison packet indicated Boyd has an IQ of 67. The other indicated his IQ is 80. At the evidentiary hearing, Boyd presented testimony from Dr. James Shattuck that an IQ below 70 indicates retardation, and that Boyd received an IQ score of 64 on a test administered by him. And then if you skip down a little further, they discuss a second set of IQ tests, and like you have to kind of parse them out because they're talking about the standards of IQ tests in there as well. But the gist of it is, oh wait, hold on, I might be reading this wrong. Andrew's IQ was presented between 70 and 80. The district court concluded that the isolated IQ score of 67 in the prison packet is not enough to compel the attorneys to investigate when the other evidence at trial contradicted a suggestion of intellectual disability, is what I'm going to say. And then it says, I don't know where the 69 came from. I swear I saw 69 in here.
Well, it may have been the 67 because all I saw was 69 and 80, so I don't know.
So there's a 64, a 67, and an 80 for sure that we have in here. And I think I've seen one more instance of him having a pretty low score. Where I'm going with this is this. Do you feel like a person on this scale, like, you know, say we split the difference and he's like between a 70 and a 75. Do you think a person that has around a 70 IQ, getting a good big dose of any of those barbiturates, which all act as true serums, is going to use their last breath to tell a lie?
I think that it could be a way. So I don't know that necessarily he was lying, but I could see where he was either trying to impose guilt on those doing it to him or trying to reassure himself somehow. I can't boil it down to the last statement of his life based on the circumstances. And so should he have been put to death? Well, I would say that this borderline situation, like I talked about earlier, even though Texas didn't have these types of stipulations where like they hadn't ruled that, like the legislation in Texas had not put things in place at that point that prevented them from putting intellectually challenged people to death. Okay.
Yeah.
And so by all accounts, it it was perfectly within the laws that Texas had set up, right? Now, is it right or wrong? Well, it doesn't matter. It's what's in play at that point, right?
Yeah.
And so there was no obligation for or to follow the law for them to not impose a death sentence on him according to Texas law at the time. And it had been, I think it had just been addressed, so it was pretty recent. Now, given that, nothing about his case at any point in time is about any sort of actual innocence,
Yeah.
right?
Yeah.
His trial, there was no, it seems to be more just the contention of like, you know, he doesn't plead guilty, but that's because they really wanted him to be put to death. And like in capital murder cases where they want the death penalty, it's not going to be a plea deal. It's got to go through the jury process, right?
Right.
Okay. And so he had confessed to all three crimes. They had evidence linking him to one of the crimes. They had evidence that he had been at the crime scene, and then they had evidence of a forensic nature that tied him, I guess, to the event, right? Blood and hair or whatever. And based on that, I don't know why he said what he said at the last moment. But I would say that it departs because even the appeals process, it has nothing to do with his innocence. Like they never say he's innocent. The only thing they say is that he shouldn't be put to death because of this. They argue ineffective assistance of counsel, citing that because he had a intellectual challenge, according to some matrix measurements, that he should get a new trial because his lawyers didn't do a good enough job, right? And so there's never this point of actual innocence that's argued. And it doesn't make a whole lot of sense to me that like that's his last statement, because I don't ever see it said anywhere else that he didn't do this.
No, I hunted around on this case, and what I started with was I was trying to find something that had happened in 1999 related to DNA that would make him think like, oh, well, DNA will let them know that I didn't do this. I even found an older entry on this old blog, the Skeptical Juror. He may still be active, I'm not sure, but the Skeptical Juror is a pretty interesting blog where it's just somebody who's like skeptical of certain cases, and they don't get super deep into them, but they'll mention some things from time to time. And he kind of had 12 years ago, it looks like July 2010, some of the same thoughts I had. Basically, this is from the Skeptical Juror's blog. In my search for the 54 innocent people that I calculate Texas may have executed, I passed Charles Anthony Boyd through my coarse filter for two reasons. First, he used his final breaths to declare his innocence. And then he quotes from an August 6, 1999 edition of the Laredo Morning Times, which is where they quote that he declined to make a final statement. And then as the drugs flowed, he said, I want you all to know I did not do this crime. I asked for a 30-day stay for a DNA test so that you know who did do the crime. Yeah, then he died. So then second, the folks at Northwestern had listed him as someone possibly innocent, but certainly executed. They have a whole bunch of people that he lists here that come out of the sort of the Northwestern cases, and 8 or 9 of them are highlighted, indicating he has other blogs where he's talked about them. And then he repeats the information that I just gave out about the Fifth Circuit Court of Appeals and the general crimes. There was a plea from Amnesty International that he references here, and they're saying don't execute him because he is, quote, mentally retarded. And they also state that there's a racial issue. I'm just using what he says there. In the Amnesty statement, they state that the 1983 Boyd's IQ test had been measured at 67. Lawyers have since stated they do not remember seeing it or other evidence that Boyd was suffering from any level of challenges they use the word retardation, but they mean intellectual disabilities. That's such a a lit word to use, but that's a quote from what they're saying. They did not have Boyd examined by a mental health professional. The appeal courts have ruled that this did not amount to any type of ineffective assistance of defense counsel. And in 1995, a federal court ordered a hearing into the claim of inadequate counsel. At the hearing, a magistrate heard evidence of Boyd's mental capabilities, including expert testimony from a psychologist and a neuropsychologist who had conducted evaluations of Boyd and had interviews with his family members. He had conducted interviews with his family members in 1992. At this hearing, the court heard that Charles Boyd had displayed signs of having learning difficulties from early childhood, but his mother did not enroll him in special ed classes because she did not want him to be embarrassed. Charles's nickname was Head because he would regularly beat his head against the walls and on the ground to receive attention. And Charles was allegedly subjected to regular beatings by his stepfather and his brother because the boy was slow to respond to their requests. At the age of 7, it was discovered that he was deaf in one ear, and it was also disclosed that he had suffered from seizures throughout his childhood untreated. In 1989, the Supreme Court ruled that it was not constitutional to execute a mentally retarded person. Those are their words at the time. And as I referenced, all the way up through 2002, there's a case holding the specific parts of that. So the skeptical juror doesn't end up saying he's actually innocent for Head, is what he calls him, Charles Anthony. He gives him like a scale basically saying that with his last gasp, he said he was innocent, and he thinks that there would be more to the story. And he says that he simply can't find it from an easy chair in his living room, but it disappoints him in several regards. I have hunted for this, a lot of information about this guy. I have not found anything additional. Did you find anything extra?
I didn't. And I think to the Skeptical Jurors blog, the author of that, I think that it says something different to him than it does to me. And perhaps you as well. I don't really know. But to me, for one thing, I do think that I don't know that beyond the request to have a death sentence commuted to life, I've never seen like questions of intellectual challenges become so prevalent because let's face it. I mean, just being honest here, if somebody has an intellectual challenge that would affect whether they should be put to death or not, that isn't going to need to be stated on a piece of paper. You're going to see it.
Say that again, just so I understand where you're headed.
I'm just saying that while, you can test people all you want, right? As far as like what your score is, if it's under 70, you have an intellectual challenge. If it's over 70, you don't, right? That kind of thing. I feel like, except in this sort of like appeals process where they're trying to get a death sentence to be life in prison sentence, right? You got to focus on the fact that they've never said he's innocent. All they've ever been trying to do is have him not be put to death, basically, which is the job of the appellate attorneys, right?
Right.
I mean, that's their job. My point, what I'm saying is that in situations where you're faced with this type of thing, it's never going to boil down to an argument over a test score. It's going to be readily apparent in the interactions of at least the attorneys, I would say, the defense attorneys, right? And I assume, and this could be, my bad for assuming this, if I were a defense attorney with a client who I felt like had intellectual challenges that mitigated their offense, right? I would be all over that. I would not, however, be doing that if it was clear they didn't have these problems, right? And all the information that's sort of given to me it might explain why he was like so mad at the world that he was, killing somebody, but it doesn't lend to any sort of reprieve as far as the fact that he was sentenced to death. I would have been just as, I mean, for all I can say, like, I would have been fine with him spending his life in prison, but,
Yeah.
and if there was an actual innocent argument that had been made, but that's never been made, right? And to me, if he was innocent, the system really failed him. I don't necessarily think that's the case, because it seems like there would have been some mention of it at some point. But I don't even hear anything like about, because I guess the argument would be like, if he's intellectually challenged, then how reliable is his confession, right? Except that's never brought into question.
Oh, I agree with you. Yeah.
And so there's never even like a challenge at that level to say like, oh, well, he confessed, but he didn't mean it, or he wasn't capable of confessing, or anything like that. It's just, we feel like this, because of his intellectual disability or intellectual challenge, he shouldn't be put to death. And that just falls flat.
Well,
And according to Texas law at the time, there was no, while, morally and ethically it would be wrong to put someone who has intellectual challenges to death, the law still allowed it at the time, it
yeah.
appears. Even though the Supreme Court had said that it was wrong. But, the states have, to an extent, follow what the Supreme Court says, but they also get to make their own rules, and it's very confusing. And so I feel like if he had come in there with like, consistent test scores at like 40, right?
Yeah.
45, that's a different story than where you've got this like borderline situation. I really hope that, in the event that someone does have the type of intellectual challenges that someone would have, where the court system would say, we can't put this person to death because of these intellectual challenges they face, because it would be a violation of their Eighth Amendment right against cruel and unusual punishment. I feel like that type of thing where it's not being used just as a loophole, I feel like it's not actually a question. Like it's just obvious.
So in this case, do you feel like it's a loophole?
I feel like that they were arguing the only legal basis that they had. So yeah, it would be, if they had ruled for his sentence to be commuted, it would have been a loophole. Yeah. Because I don't think that he was intellectually challenged to the point that he was being put to death for something that he didn't comprehend what he had done.
Yeah.
I don't see that. Now, should he have, the jury decided to put him to death. And, because of the way our system works, I can't sit here in my office and say, well, he shouldn't have been put to death, right? Because I didn't go through that whole process with them. But I will say that there never appears to be any actual innocence arguments. That would change my entire perspective on the case, okay? But in the event that they had ruled that his, borderline testing rendered him to be intellectually challenged, therefore not, a candidate to be put to death, having been found guilty of this capital murder case, then I would be okay with that, even though it is a loophole, right?
Yeah.
The fact that they didn't find that, and, I don't know what to make of his proclamation. It is interesting, and it's just really hard to fathom that like it never came up before then, because from what I can see, it never came up before then, right?
Yeah. Well, so this all comes up because I've been looking at these cases of women found in trunks and bathtubs in Texas in the 80s. And honestly, it all comes up because one of those cases got solved earlier this year. And it had always been like sort of stuck in my head. And I do think like it's going to be like a case that we go and look at. The clipping I have that, like, I don't even know why I have this clipping or like where it came from, but and this is in San Antonio, so it's a couple hundred miles away. But in 1987, there was this woman killed named Diana Lowry who was 30. She was found in her bathtub. She had been asphyxiated and sexually assaulted. There was another woman named Maria Teresa Gonzalez. She was, I think she was 52. She was found in November of 86 or 87. I think Diana is in February, and then Teresa is in November of 86. But here's how they come up. So this guy named Larry Moore, he ends up being arrested in 2005 for the Diana Lowry murder from 1987. And then the case gets kicked before it goes to trial. So then in 2018, he gets charged again. And now in March of this year in San Antonio, he gets found guilty. And there are multiple mentions of how they solved this case, but it's one of those cases where the DNA from the crime scene is what gets him, and they go about it trying really hard to get this guy free. And I think if they went and ran these cases that they thought were linked back then, but for some reason over the years have someone like Maria Gonzalez just kind of fell to the wayside. Nobody really did anything with that case. It gets mentioned. It's very similar to Diana Lowry's case, which is what Moore was accused of specifically. An autopsy revealed she was strangled, she was sexually assaulted. It took years to build this case. He is now sentenced to life in prison as of March 2022, I think. Yeah. So this is an article out of KSAT, March 25th of 2022, where he has just been convicted in Bexar County after 6 hours of deliberation. They found him guilty of capital murder, but ultimately sentenced him to life in prison. He'll be eligible for parole after serving 40 years. He's 65 years old. He'll be 105 years.
So, and you're saying, is he still professing his innocence?
Who? Moore? Larry Leroy Moore? Yeah, his defendants, like, he's going to go through the whole appellate process. He had moved to Arizona by this point when he was finally arrested. And he had ties to Dallas, and there's multiple other bathtub stranglings. What I've been looking for, though, or did something similar happen to any women after Charles Anthony Boyd went to jail? And the reason I brought up Diana Lowry is she's also in 1987. Unfortunately, she's before the bathtub slings in Dallas. That's an unusual way to die. For women to have things around their neck that aren't strangling them, and for them to die as asphyxiation by drowning in a bathtub, that's unusual for that to happen.
Right. And part of what I initially saw with Charles Boyd's case, it seemed like he was like, all of them happened like in the same apartment complex, and he lived in the apartment complex.
Yes, at that time.
And to me, like, that just like screamed. But again, any sort of like, I didn't do this at any point in time
might have gone a different way for him. Yeah.
Well, it would make me reconsider the situation. But when you just have somebody confessing and then going through the process and then trying to not be put to death based on a loophole, it just doesn't add up. I don't have a whole lot of sympathy for somebody like that.
I don't. But if he truly is not understanding what's going on, and he really does have that low intellectual capacity, I question, like you said, at any point in time, if he says, I didn't do this, well, this guy says, I want you all to know I did not do this crime. I wanted to wait for a 30-day stay for a DNA test so you would know who did the crime. I don't think he understands DNA there, or he's implicating a relative, which I would believe either way. But he did say it.
I don't understand why he didn't say it earlier, though.
He didn't want to be a bother.
I find that hard to believe. I mean, if that was the truth of the matter the whole time and it came out, like, I don't see why you would wait until that moment to say it if you had never said it before. it doesn't make sense.
Well, I'm not necessarily disagreeing with you. I'm just saying, and I think the way I posed this to you, I would say, well, this is interesting
I
because of the
said
last
that
words.
I said that if he truly was innocent, then the system failed him. I admit that.
Absolutely.
And I personally would have had no problem with him living the rest of his life in jail. It doesn't matter to me, but he went through a process that anybody in his situation would have faced the same exact thing, right? And a jury would have decided for anybody in that situation. Having the confessions and all that stuff, none of that is going to, bode well. If it was the case that all along he couldn't quite get it together to say he didn't do it, then, maybe he was more intellectually challenged than we thought. And that would make everything seem, it would be really wrong. It would be tragic. But under the circumstances, I would tell everybody, you need to speak up. If you haven't done something that you're getting in trouble for, you need to speak up, regardless of what anybody tells you.
Yeah, I don't know where that cutoff is, where someone would potentially not speak up.
I don't either. And for him to say it like he did at the end, I mean, that means it was in there the whole time. So
Yeah, and if I hadn't found other bathtub murders that sort of fit like the timeline and this, I've got this huge 500-mile circle drawn, and they're just inside of it. It's not even one I really think I'll ever be able to figure out. But when you go hunting for bathtub murders, these guys come up, and then the other ones in San Antonio come up, and then there's some in Arizona that come up, which is weird. But this guy saying he was innocent caught my eye, and I just wanted a chance to be able to talk about his case and to talk about like people who end up in capital cases, I guess, like with maybe not the wherewithal to do anything about it. It's really weird.
well, and I would hope that, and obviously, as especially during this show, but just getting older and having more experience with things, I hope that every single defense attorney out there that does capital murder cases would be aware and everybody's entitled to the best legal defense possible, regardless of whether they did something or not. And these special circumstances that come into play, like having an intellectual challenge defendant, you would want to represent your client in the best capacity possible. And I would hope that that's what happened. And I feel like interacting with somebody is the best way to really tell if, they need special consideration. Does that mean that always happens? Well, I don't know. I don't have the answer to that. I just know that it's not in anybody's best interest for us to put somebody that isn't capable of understanding what's happening to them to death, right? That's wrong.
Thank you for joining us. We are sponsored by LabRottiCreations.com. You can check them out at LabRottiCreations.com, and you can still use the code CRIMEXS for a fun pop pet portrait of your own pet. You can also reach us on Twitter, Instagram at TrueCrimeXS, or you can give us a call if you know anything about any of the cases that we're talking about at 252-365-5593. You can also reach us at Gmail at truecrimexs@gmail.com, and you can check out our website at www.truecrimexs.com. We'll see you next time.
This is True Crime XS.
Well, somebody's got to talk about it. If we don't talk about it, you never know, what'll be the next thing that happens in this egregious. I get so far down some of these rabbit holes, and I look at it and I'm like, am I just like ranting at this point? Like, am I just ranting to myself about this case?
This particular case?
Oh, no, I'm saying like the rabbit hole that I'm down, whatever it is I'm down at the time. Like in this instance, like I haven't even started to really rant about this so much, but I'm saying sometimes I drag like everybody with me and I'm like, hey, let's go check this thing out.
Well, and so were you thinking that he was perhaps innocent?
Charles Anthony Boyd,
Mm-hmm.
he didn't kill those women.
So what happened then?
His case falls into this space and time for me where he's convicted and he's executed, which means they destroyed the evidence. But I would say if you could really do DNA evidence, I don't even think so for a long time I was hung up on stepfather, brother, like could it have been them? And here's the thing, I definitely believe he was at the crime scene. I believe that Charles Anthony Boyd went into at least Mary Milligan's apartment after
Well,
the
he had her
fact.
stuff, right?
Yeah. And I definitely believe he was a burglar. And he may have done whatever else is on his criminal record in here if you skim through. I don't think that he's a serial killer that knew to put women in bathtub to destroy evidence.
But how would you explain him having her belongings the day after she was murdered and pawning them, but him, I mean, not having killed her?
The thing that stood out to me is I could never figure out this one statement that somebody made was whether or not he could drive. Her car was driven away from the apartment complex and
Right.
abandoned.
Right.
Supposedly, he could not drive.
Well, I mean, I don't, there was no argument to that either. He could, the fact that it was abandoned kind of lends to somebody that took it couldn't drive. They maneuvered it and then realized that it wasn't going well, so they left it. But I feel like if you don't think that he killed the women, that I feel like our episode is really skewed.
Why?
Well, because you didn't say that.
I don't. So when it comes to people like this who have these type of challenges, I cannot get past the dying declaration. You know, our court system allows dying declarations because they're generally considered to have weight. This guy's dying declaration was, I didn't do it.
Right, but then he goes a little bit further and says,
Yeah, I was waiting for 30 days for somebody to figure out who did do it.
no, that's not what it said.
That's what it meant, though. He doesn't understand DNA.
Okay, and so
So you think he was like pulling somebody's leg at his death? I don't think he's that smart.
I don't think he was pulling anybody's leg. I think he was saying like what came out. I mean, maybe he didn't do it. I'm just saying that if you don't state your opinion when we're talking about it. Well, you just went along with everything I said. You didn't say like, oh, he didn't kill those girls until at the very end.
Well, you can talk about it from that perspective. But I already knew you were going to kind of shut me down about it. But like, I'm pretty sure he didn't do it.
How did I shut you down?
I think you would if I had just said that. I think that you would shut down the idea that he didn't do it.
I was under the impression you were going to argue the other side.
Yeah, but that's the thing. I don't know how to argue it in this case. Like, his is a case where this is what drives me a little nuts about it, I think. You could, like, in 1999, when this guy gets executed, people would have known enough to test DNA, enough that, like, this person who, I worry about cases where they sort of pick one thing that they can prove. And that was going to be, like, in his case, it was going to be that he was intellectually incapable. And they didn't really do that successfully. But, oh my God, somebody just posted on Reddit, like within the past 2 days, that he was a serial killer active in Dallas. Does he strike you as a serial killer?
This guy?
Yeah.
No.
So this guy ends up being a serial killer as far as like...
He was a... Okay, so assuming he's guilty, which he was found guilty and put to death for.
Oh, yeah, totally.
One murder, okay. But he confessed to 3, according to the record. That is, plastered across all the appeals. Now, I never understood them to say that that his intellectual challenges would have prevented him from committing the crime.
No, that's the argument that they made, was that they should prevent him from being put to death.
Right. That was it. And it wasn't even a law in Texas at the time that people who were on the cusp of that.
Yeah, it had been vetoed like right before all this happened.
And so it wasn't even really a legal point, except that the Supreme Court had already held what they held, right?
Yeah.
But it couldn't force Texas to do it. Now, there's parallel roads here, though, right?
What do you mean?
Because, well,
Like,
if
he could still be that low, but have done it type road.
no, the parallel roads here are the fact that, like, I looked at it from the point of view of what happened legally, right?
Okay.
There's never an appeal professing innocence. There's never an appeal about anything besides this loophole, right? That's it. That's all that is appealed that I saw.
Yeah, no, you're 100% right. And I've gone through like all the news articles on this. Like, it's never even brought up that, like, there's never a question of innocence raised by anyone.
Right. And so, I would hope that somebody would have raised that.
Well, that's what bothers me about the case, I think, is like if he doesn't know to raise it and he's just like, oh, these people are going to help me, these lawyers, like, who defends those people?
Well, I mean,
nobody is the answer.